Welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm joined today by attorneys Nathan Seltzer and Clayton Calvin. And
G'day.
We have very exciting drop just this morning. We're recording on Monday afternoon. Just this morning, we got Trump v. Cook and Trump v. Slaughter, and we're going to talk about them both in a timely fashion.
The unitary executive has
unitary
arrived.
executive. It has come home to roost. And I'm curious about you guys. How surprised were you that these didn't both go the same way?
That was a little weird.
Yeah, although not entirely surprised. I mean, I didn't think that... one is obviously much more... So just to give listeners a little bit of background, the Slaughter case is about the president's ability to fire a commissioner or board member of the FTC, and Cook is about his ability to fire somebody on the Federal Reserve. And so it didn't totally surprise me that those might come out different.
A little differently,
because
yeah.
they're different agencies, and one is a lot more drastic than the other, one might say.
They're nuanced, and I think, especially having listened to the oral argument in both, I think we all kind of knew there was a chance that they would go different ways. But I was still a little surprised. I kind of thought that they would both go the same direction. But so
Party presentation, man.
Yeah, and that's what it comes down to a certain extent, is party presentation. But let's start with Trump versus Slaughter. So Trump versus Slaughter, and y'all will have to forgive me, I am going to be reading a little bit more than I normally do because this just came down.
Yes, and it was 100. I think this one was
3 hours
like over 100 pages, and then Cook is like 83 pages. So bear with us.
Yes, so we're doing our best. So this case comes out of Trump's firing of two FTC specifically, and it's important, the Federal Trade Commission employees, not employees, board members, Rebecca Slaughter and Alvarado Bedoya. I don't know how to pronounce his last name. No cause given, just Trump said, I don't want them running my agency anymore. They're not helping me achieve my goals as the administrator for this country. And Slaughter sued and said, no, my position is protected by the Constitution. And she was
specifically protected by a statute, the four clause removal statute.
Yes. That she could not be removed except with
with the statutory removal protection.
Right.
Sorry.
As these things go, of course, it's better for the president to remove someone and give no reason and say, I'm just doing so and violating the law, than it is to actually give a reason.
Right.
Like, it's better for the president to get his way, at least, which is kind of an interesting outcome here.
Yeah, so the Supreme Court ruled in favor of President Trump and said, he can fire her. The four cause removal protections violate the Constitution's separation of powers clause. Well, the vesting clause specifically, the clause that vests the executive power in the president.
The executive power shall be vested in a president of the United States. That's what it says.
Exactly. So this is what Article 2, Clause 1 and 3, something like take care clause is 3. So this is basically the section of the Constitution that in very broad strokes says the president is the executive. Period. End of story.
Right. Yeah, some people point out that like the Constitution it establishes the three branches, but it's more like it establishes Congress, and then it establishes the presidency, because the rest of the executive is actually created by Congress.
Right.
And then it establishes the Supreme Court, because the other courts are also established by Congress. So it's a little narrower than people might, the constitutional text is a little narrower than people might think.
Right. And then where the opinion starts, and where I think we should start, is actually a little bit before we get to the Constitution itself, because what the vesting clause is born out of is every bit as important as what comes out of it, which is this notion that at the time of the Constitutional Convention, most states had multiple executives. They had several different executive offices running around attempting to enforce the law at the same time.
It's not a foregone conclusion that every executive has to be housed in one individual. That was a deliberate decision that they made when they were ratifying the Constitution, with the information they had at the time, observing all of the different governors and sort of thinking, they don't seem to be able to wield a lot of vigorous power.
Some states had a governor that was very weak and could only act sort of as with
the advice of councils
they
kind
had
of thing.
A board kind of running the state.
Yeah. And one of the criticisms, I think it's actually a really important criticism that the justices, specifically Justice Roberts, who wrote the opinion here, and was joined by Alito, Gorsuch, Kavanaugh, Barrett, and Thomas. What Justice Roberts points to is this accountability problem that Congress, the original Congress was designed to make laws, and then the enforcement of those laws is someone that should be directly accountable for the way that he chooses to enforce them. Mm-hmm. And when you have a committee of 5 or a committee of 3, there's a lot of hiding the ball and a lot of a lack of transparency. And so for purposes of accountability, particularly Madison really urged this, what is it called? The decision of 1789, that we should have one executive whose job it is to be accountable. A place where the buck stops, really, is what they were looking for.
So fret not. They did have a lot of debate, and
leading up to the founding and after the founding in the first Congress.
It wasn't like this decision was made.
Yeah.
And it is possible, but there are other legitimate ways of constructing government. And here in Texas, we have, different executive positions, the AG, lieutenant governor, the governor, they're all separately elected, and they have separate spheres of they're all executive positions, but they're all separately elected, and that can work for a government, but that's not what was decided and ratified in the federal Constitution at the time.
There's a great quote in here from James Wilson that instead of being the fetus of the monarchy, unity in the executive was the best safeguard against it, for only a single person could produce the vigor and activity necessary to preserve the Constitution's separation of powers, and only a single person could make the office responsible to the people. That was I would say cleaned up. It's James Wilson cleaned up by Chief Justice Roberts a little bit, explaining that the purpose was one person to preserve the separation of powers and a single person to make the office responsible to the people.
If they're directly elected by the people, then if the people get a sense that they're sort of an unaccountable executive agency, perhaps an independent agency that they didn't have a hand in choosing, then the people can actually have something to say about that, and they can elect somebody that can make changes. And again, maybe if we elected directly all the different department heads in the country, that could also satisfy the problem, but that's not the way that they went about it. They said, no, one person is more efficient and it's more accountable.
And we're also looking at the take care clause, right, which is Article 2, Section 3. It says that, among other things, it says, he, being the president, shall take care that the laws be faithfully executed and shall commission all officers of the United States. And they kind of put those in the same section of the Constitution. So they're indicating those things are related, that the president is responsible for taking care that the laws be faithfully executed, not Congress, really. Yeah.
And there's an assumption underlying this that was present at the founding, was present in the Constitutional Convention, which is that, yes, the president is the one executive power, but he also needs agents. And that's why we refer to them as agents. It's agencies, because they are acting at the direction of and at the behest of the president, in a truly agent sense.
Yeah, they're subordinate to him, and what's the word that they use? They're his superintendents. They're subject to his superintendents.
Yes.
And the question here in this case is whether the superintendents in superintendency includes the ability to fire someone, notwithstanding the competing congressional statute terminology that insulates those people for cause.
So, is this a good time to talk about independent agencies and how that came about? Why is it even possible for the president?
Tell us where independent agencies come from.
This is sort of the 20th century sort of phenomenon that the independent agencies started being created by Congress because it was thought that this was sort of this technocratic idea that kind of ushered in by Woodrow Wilson and the progressive era around the turn of the century, that the technocrats, the people who really understood whatever the issue was, like say the Department of Energy or Transportation, the people that were educated and were most fluent in that if they were the ones running the show, that the country would be better run. And it was really too complicated for rank and file voters and people like that to have direct accountability. And so the president, being directly elected by the people, that he should not be able to just remove these technologically knowledgeable bureaucrats, these technocrats who are running these agencies, and if that was the system, then it would run a lot better. So they started creating these agencies, Congress did, that were insulated. They were appointed by the president. The head of the agency was appointed by the president.
Because the Constitution is very clear that needs to happen.
Yeah, yeah. The Constitution says that the president shall appoint, but it doesn't say anything about removal. up to this point, up until about the 20th century.
It says that he shall appoint with advice and consent of the Senate.
Right.
But he doesn't say anything about needing the Senate's consent for removal. Yeah.
Doesn't even say anything about removal.
Anything at all.
Silent
Yeah.
on removal.
Yeah.
And so it was just up to that point, and it was the custom, and it had been done, that the president would remove officers that were not behaving the way he wanted. But the Congress began creating these insulated positions where they said you can appoint with advice and consent of the Senate, just like the Constitution says, but you can only remove for cause. And they tried a few variations of this. There was the variation where Congress actually had to be involved in removing them. And
yeah, we've said for cause a few times, just for like some listeners that might not know what that is. It's a legal term of art, meaning, it can't be like based on just political desire. It has to
usually
be
it's like
impropriety.
You did a bad thing.
Yeah, like
it's not just
fraudulent.
I don't like you. It's
right.
I can articulate a bad thing that you've done.
Yeah. And there's a whole, I think one of the concurrences goes into how that has an ancient common law meaning that's pre-established, and that, maybe that's in the Cook decision, but yeah, it's a predetermined legal meaning that has to do with like impropriety in office specifically, but not political desire.
Yeah, not like you're not doing what the president says.
Yeah.
That would not be
right. That's not for cause. But you cheated on your taxes. You murdered somebody.
Yeah,
maybe
did something
would
weird
be
with
bad.
buying a house.
Yeah,
We'll see.
Maybe.
Yeah, we'll see.
And so these
We'll
for cause for removal provisions are one of the ways that the I guess the technocratic, the Wilsonian idea of a technocratic government insulated these agencies and these officers from the political vicissitudes, the democratic vicissitudes. That's what Congress was doing when they put those in there.
And the president, all politicians necessarily have to balance competing interests. The idea was that the technocrats would not have to balance competing interests. They just do whatever the right thing was.
Right.
And there would always be an objectively right thing that didn't require balancing competing interests. It had a lot of sort of subordinate ideas that were required to believe in this system, and those ideas never really panned out. Of course, all decisions that government makes.
There's a great little side swipe from Justice Gorsuch at Justice Kagan in his concurrence on this. She refers to it as a quaint.
Yeah.
In one of her law review articles, this is an aspect of history that we now view as quaint, and Justice Gorsuch kind of calls her out on that. That we at one point thought that if we had enough experts running the country, everything would be just fine, and we wouldn't need to worry anymore. The experts will take care of us.
And that, in fact, is the quaint idea.
That is quaint,
yeah.
according to Justice Kagan.
But Justice Jackson would say, no, that's really the way it should be, even right now. And a lot of people, I think that's still very much an idea. We want, even us sitting here, we kind of want someone who knows what they're doing to run.
No, expertise is a good thing.
Yeah.
But you need expertise and you need democratic accountability on that side, which is part of the reason they, instead of electing each and every department head, we have it appointed by the president. So it's a little bit more removed, but ultimately, like, you need to, if they're doing something that's against the will of the people, like, you can't be governing people.
Well, and even more pragmatically, I suppose, than that, it's the simple fact that the Constitution that we have provides for a unitary executive. So even if theoretically it was better to live in a world where we had just these clouds of experts that governed us, that's not the Constitution we have.
Right.
The Constitution we have says we have one president whose job it is to execute the laws.
Yeah.
But we get into really weird territory, starting with a case called Myers, and then we get into a case called Humphrey's Executor. So Nathan, why don't you walk us through what happened in Myers?
Yeah, so broad strokes, Myers, 1926 case.
Yeah.
And it was Myers v. United States. Myers was a postal worker in Oregon. He was appointed by the president, but he had removal power was taken away. The president was not given removal power. Right. So he was insulated from removal, and the president fired him anyway. So Myers... And we don't actually know why. I think it's interesting. It's lost to history. Like, we don't know.
For whatever reason, Myers fell out of favor.
Yes.
But, like, the postal master of Oregon is, like, a very narrow thing for the president to care about so much.
We do know why, and a slight spoiler alert for about 5 minutes from now, why Humphrey needed to be removed. But that's another story for a few minutes from now. Okay.
So anyway, for whatever reason, the president didn't like the postmaster of Oregon, fires him, and... Myers sues. importantly, I'll just, as an aside, Myers sues not to get his job back, but sues for back pay. And I'll say why that gets important when we get to that part. And so it goes to the Supreme Court, and the Supreme Court is adjudicating whether or not Myers was properly fired by the president or whether he should be entitled to back pay. And the Supreme Court says that the statutory protections that prevent the president from firing Myers were not constitutional, and so they're basically ignored, and Myers is fired and doesn't get his back pay. And so that should be...
That's a pretty broad principle.
That would be the end.
That reiterates, Madison in the first Congress, that reiterates like a whole century's worth of understanding of the issue, the president's ability to remove executive officials.
But this is important for one specific reason, and that is that he is a postmaster. Mm-hmm. He is not part of what we would consider a traditional agency that is created by Congress. The postmaster is an office that's created, well, sort of, tangentially, created by the Constitution. So it is not quite the same, at least that's what we get to 9 years later in a case called Humphrey's Executor, which deals specifically with a firing from the FTC. So Clayton, tell us a little bit about what changed and how we got Humphrey's Executor.
Yeah, so it's particularly relevant to this case, to today's case, because it was as today was involved an FTC commissioner, so did Humphrey's Executor back in 1935. So 9 years after the case Myers that Nathan was just talking about, the court actually carved out a potentially narrow exception. It's basically kind of like one of the only exceptions to this general rule.
Well, it also becomes the exception that swallows the rule, but we'll get there.
Right. So William Humphrey was also a FTC commissioner, and he was fired by FTR specifically because FTR just was like, I don't think you align with my agenda.
FDR,
which he totally didn't.
He
also.
totally didn't. I have to read the way that Justice Roberts describes this because I find it funny. The case arose out of President Roosevelt's decision to fire one of President Hoover's appointees to the Federal Trade Commission, William Humphrey, 2 years into Humphrey's 7-year term. Humphrey lauded Hoover as the foremost figure of the world, a man who fought back against the demagogue, the fanatic, the reformer, and the fool. On the commission, Humphrey sought to do the same. He spoke often to the press, described the FTC variously as a public bureau used to spread socialistic propaganda, a bureaucracy gone insane, and an instrument of oppression and disturbance and injury.
And he was a chair of the FTC.
And he's a chair of the FTC while he's referring to his own agency as an instrument of oppression and disturbance and injury. So Roosevelt was like, no, I don't want you running around slandering my agency anymore.
Right.
Thanks for that.
You can't go AWOL.
I wish more heads of federal agencies would be so honest about what their agencies do.
I mean, he had strong feelings and he communicated them thoroughly, and I probably would have agreed with him about a lot of those things.
Yeah, but what's important here is the president did not. And he said, actually, you work for me. And legitimately, I work for the American people. They elected me. They want the FTC to do things that I want it to do. That's why I was elected. And elections have consequences. And so I can't just have this rogue member of my agency just like mouthing off and trying to undermine what I'm doing because I'm the president. And I was elected. And by the way, I think that's like kind of at the core here is that the president is the only, we can't emphasize enough that the president is the only elected member of the federal executive.
Yeah.
So he represents the electorate in a way that these other officials don't. So anyway, so he fired, or he tried to fire Humphrey like a bunch of times.
In a one-line letter, he just sends him a single line, "You're fired."
Anymore. Yeah. But Humphrey refuses to quit and all this stuff. And so he's refusing to quit from this job. And but then he dies. Yeah, he just dies.
And that's why this case is Humphrey's Executor.
Yes, rather than just Humphrey.
Right.
Yes.
Right.
And so then his executor comes along and takes up his case, sues for I guess back pay for
because
his estate.
He's dead. So
his estate just
he's not getting his job back.
Yeah, that would be quite an overreach of judicial injunction power to raise someone from the dead in order to come back into the
Okay.
But anyway, so
zombie
give it to his son or something where the executor designates.
Yeah, and so so the court though actually upheld these for cause protections for now deceased Humphrey. And the reasoning, so it carved out an exception to the Meyer case that Nathan was talking about. And the reason being was that Actually, he wasn't an executive official totally, because he exercised quasi-legislative and quasi-judicial power, and that's what the FTC was designed by Congress to do. And so because he was an executive, he doesn't get to be fired by the chief executive, which of course just runs headlong into another problem, which is also discussed in the Slaughter case. It's a separation of powers problem.
Right.
You can't just he's amassing. It's like Madison said, the definition of tyranny is all the functions of government being centralized into one authority. So he's a legislator who was appointed and not elected, and he's also a judge. Yeah, so he's
and Humphrey's Executor goes out of its way, like super far out of its way, to describe just how not executive he was. Like they disclaim any executive authority whatsoever.
I don't think they're not even aware of the separation of powers problem, it seems like.
Right. So they're saying this is quasi-legislative and quasi-judicial, and therefore the executive can't fire this guy.
Right.
And I think it's an interesting little side note that Humphrey's Executor came down on what the New Deal politicians referred to as Black Monday. It was the day that the Supreme Court issued a bunch of opinions just knocking FDR and saying, no, you can't do all these things. You don't have as much power as you think you have, which I think largely contributed to the stitch in time. And it becomes part of the movement that we see today of how the court responds to the presidency, basically.
Right.
And it's fundamental in all that.
And the court is now saying in this case that this idea of this officer is wielding quasi-judicial and quasi-legislative powers. They're also saying that just cannot be the case. That the power they're wielding executive power, that's the only thing that they constitutionally could be wielding. And so this idea of this is like not really an executive function or whatever was not true. Yeah, it's not true even at the time.
Yeah. And it's especially untrue now that there's actually been a lot of executive jobs added to the FTC. So it's just kind of indisputable. So the majority talks about how, it's changed, it's become more executive, so that's not true. But also, Humphrey's Executor sort of fails by its own metrics because it wasn't even true at the time that it was decided.
Yeah, so there's a great quote from Justice Roberts. From the start, Humphreys was tethered to a highly circumscribed and almost fictional view of the FTC's role. Humphreys, by its terms, applied only to agencies that occupy, quote unquote, no place in the executive department, are independent of executive authority, and exercise no part of executive power. Indeed, Justice Sutherland took pains to emphasize that the character of the office, executive or non-executive, would determine the result of future cases, and to reiterate that the court's decision was limited to officers of the kind here under consideration. Now, of course, the result of Humphrey's Executor, was that Congress was like, cool, that's how we're going to make all of our agencies from now on, so that the president can't mess with them. Ballooned independent agencies. It created a situation where almost everything in American life has an independent agency that's governing it.
Right.
And it's interesting and I think important that this comes up specifically under the FTC because Humphrey's Executor is directly implicated, and the question comes before the court, are you going to overrule Humphrey's Executor? And the answer to that question was yes.
It says, I think he says, like, to the extent that there's anything left of Humphrey's Executor, because actually in keeping with the main principles of this case and all the others, there have been a number of cases since then that have chipped away at it, said, hey, these removal restrictions are not okay in these other situations, but never actually overturned Humphrey's Executor. And here we have it squarely overturned.
Yeah.
And it's just just put in perspective, this is just overturning like the one narrow exception to the overarching rule that's always been the case. There's nothing actually, it's almost like there's nothing that remarkable about it, legally speaking, except for that it will have a broad ripple effect.
Well, we won't have to hear the unitary executive theory anymore.
Yeah, because it's just obvious.
The unitary executive law. I think the way that Justice Roberts crafts this is very interesting here, because this looks very similar in the terms of how he frames it up. It looks very similar to Chevron, which was overturning the judicial deference to agencies, and it looks very similar to how they framed up the Lemon test in Lemon v. Kurtzman, which was a different constitutional test related to the First Amendment. And in both times, the court sort of stops employing it, starts limiting it, cabineting it, making it smaller.
Kind of fades away.
And then they don't use it for a while, and then eventually somebody pulls out the dagger, and in this case, Justice Roberts, and ends Humphreys. But we've seen this now, I think, 3 different times in recent memory where they've taken a constitutional test that had been broadly applied and then made it smaller and smaller and smaller and then finished it off.
Yep. Yeah.
There's on the stare decisis issue, because ultimately that's what this boils down to, is the question of, is this just stare decisis? Are we just going to go along with what
Just
prior
because.
courts have said, just because that's so? One of the considerations is reliance, right? And there's Justice Gorsuch, joined by Justice Sotomayor, who argues stare decisis in her dissent in this case, said, in its valiant search for reliance interests, it is the dissent, in this case referring to Justice Sotomayor, that somehow misses maybe the most important one, the reliance interests of the American people in the preservation of our constitutionally promised liberties. I love that line with every fiber of my being. That if stare decisis is standing in the way of your constitutionally protected liberties, get rid of it.
Yeah.
Get rid of
You're
whatever
relying
case.
on the wrong thing.
Yeah, you have a strong reliance interest in the Constitution being enforced the way that it was written.
Yeah.
Lean on it.
Right. That's why it was written down. So,
That's why it
these
was written
opinions
down.
don't just carry on their own force.
Right,
They can be
right.
overturned after a while.
So what Justice in dissent, what Justice Sotomayor says, I think the nub of it is, it says the court forgets its place. For most of our history, the court has rightly left the removal question primarily to its co-equal branches, meaning the other branches of government. Today's majority, go
The
ahead.
Madison decision of 1789 was a congressional decision, in fairness.
Yes.
A very, like, the
It was a very
most
influential
congressional.
one. Yeah.
But yeah, so that's a process
opinion.
called liquidation, right? Where we're looking at what did the
Right.
Congress do right after the ratification of the Constitution. So for the say that the court has left removal to its co-equal branches, what she really wants, there's two co-equal branches, right? There's the executive and the legislative. She's certainly not saying that we've left it to the can't believe that went off. Certainly not saying that the co-equal branches are the executive. So the co-equal branch she's referring to here must be the legislative branch. So what she's saying is, in framing it as a separation of powers thing, she's saying, no, Congress gets to decide.
Congress gets to decide this thing that is in contravention of, potentially in
Constitution.
contravention of what the Constitution says, which is our role to say what it means. So,
And I think to give a little bit of grace to the dissenters in this case, I understand the knee-jerk reaction.
Yeah, totally.
Because this gives an immense amount of power to the president.
well, it's not that this does, but
Well, okay, that's
the effect,
correct.
the practical effect of this decision marginally right now, that is true.
What it comes down to is the original sin of Congress, right? Which was giving so much power to agencies with this belief that somehow they would be able to reel it back in.
And then papering it up with, oh, well, now they're less democratic also, so we're safer from them.
Right, we're safer now.
Doesn't totally
That's
make
not
sense.
how that works. And Justice Gorsuch writes just a beautiful concurrence in this case, articulating the new reality, I guess, and why we should be concerned and how we should be concerned about what Congress has done. And he says the consequence is a ratchet effect. Authorities Congress once delegated by simple majority may now require a veto-proof supermajority to retrieve, because presidents are not just going to give up this power that they have now. They're not just going to turn around and say, "Oh, you know what? Yeah, I don't need that. I don't need that power to remove. You can go ahead and take away these agencies from me. You can go ahead and take away any guard." Presidents are not going to sign those bills.
Unless it's a president that runs, to the extent maybe this president did, and I don't know to the extent that he has followed up on that or not, but there could be a president sometime that runs on that platform and says these
Absolutely.
agencies have too much power, and
They might-
I'm
he
going to
might
work with
exist.
Congress to take that out, which
But
would be a
I
great
don't-
American man if that
Like George
or woman.
Washington reincarnated is
Yeah.
pretty much the
Right. I don't
End of
want to
list.
have to bank my future on George Washington reincarnated. Like that feels like
Well,
such a
no,
stretch.
but it would be banking based on what the electorate wants,
Right.
And the electorate. I mean, now that this issue is put squarely kind of more in front of the electorate, we know that we can vote for somebody who. Maybe I'm naive. Maybe I'm being a Pollyanna about this, but it's not inconceivable that they could do that. And also, I think. Or I'm sorry, were you finished about?
Well, I had another thought.
Yeah.
Well, actually, Justice Gorsuch has
Keep
another
going.
thought
Yeah,
on this front.
Keep going with him.
And that is that the answer might be from the court itself. He says, perhaps then, if any real response is to come, it will have to come from this court, and that's hardly unfair. To be sure, Congress had a hand in creating the problem we now face, but this court bears responsibility as well. It was this court that decided Humphreys. It was this court that sat by while Congress delegated vast legislative and judicial powers to one independent agency after another, and it is this court that today allows the president to remove those agencies' leaders and exercise effective control over all their powers. If the task of fixing a problem belongs to those who made it, this court has some work to do. And I think he's absolutely right. He's talking in the context of, if we are going to realign, which is exactly what this case is, this is a realignment of an office to its executive powers.
Yeah.
If we're going to start realigning, we got to finish the job. We have to.
This is just one step in a bigger process here.
We have to start peeling back the layers of this onion until we come to a place where we are where the Constitution originally demanded that we be.
So, like, in a nutshell, what would we say to somebody who is, to assuage the concerns of somebody who's really concerned that they think that this decision means that now we have an imperial president who can rampage through the land and isn't constrained by law anymore because he can just like fill the executive branch with loyalists or what have you. What are the remedies? He says, well, the court needs to step up and say
non-delegation doctrine,
and say Congress isn't allowed to delegate that amount of power to the executive in the first place. And also, I think implicit in that is Congress needs to be a lot more precise in the way that it drafts laws, so that way what the president can even do in the first place is the product of negotiation and the democratic process. There's a few other, it's not like this just untethers the president from the law.
Right.
Like the president still has to act within the law, and the judiciary is still there to prevent him from violating them.
So what is Justice Gorsuch hinting at, saying that this court has some work to do? And I think that you guys both touched on it. Like, the question that all the justices are asking, I think, is, would Congress have delegated these powers if they knew that they could not put this
they could never get it back?
Yeah. And now that they know that has happened, Congress has the power and the wherewithal to rein in and be more specific in the powers that it gives to the executive.
But it doesn't answer, would Congress have delegated the powers in the first place if they had known that, because now the restrictions are gone, at least on this position, would Congress have delegated those powers?
Likely not, right? Because that's why all those compromises are in there.
Which is why there's an interesting debate in the legal field at this point in time, which is it truly fair for the court to just strike one line from a statute? This severability issue, that is, the statute passed as a whole the way that it is. So are you really allowed to just cut out the words "for cause" from the statute? Or do you have to kill the whole thing? And I mean, obviously the court doesn't have an appetite to kill the whole FTC right now, and nobody asked them to. But honestly, that seems to me to be a more fair way to do it, because the law as it was created,
to the drawing board.
Right. The law as it was created was it was a liquidation. It was, this is everything that we've discussed, everything that we've decided, every meaning that we intended to put, we have distilled into this one opinion. And if the court is going to cut any piece of that, they are cutting the whole of it.
Right. They're creating this law that we didn't pass.
But what the court has done is what the court has done is said the executive is much more powerful than what Congress had in mind when they were creating these agencies.
Right.
The chief executive, the president, is more powerful. The question now, I think, is, and perhaps what Justice Gorsuch is hinting at, is that we have lurking out there also the non-delegation doctrine, which says that Congress cannot delegate its powers to the executive
in an unlimited manner.
Without limits.
A lot of these agencies do that. That is a separate problem. They not only exercise executive power, but they exercise legislative power. They promulgate rules that are quote unquote interpretations of statutes, but really they're sort of like, sometimes they're too broad. They're actually just almost like a new law, and then it binds private citizens with those new laws, and then it also has its own courts, so that the judge and the prosecutor are actually on the same side. And so there's just a lot of things wrong with that situation. And this decision now doesn't fix all of those things that need to be fixed. All it does is it puts executive power back into the hands of the electorate, because the electorate chooses the president.
But here's where we are, though. If Congress can delegate without any limits its powers to the president, and the president is now, the executive branch is now unitary, run by the president, and he can fire anybody. There's no really, independent agencies are no longer independent, potentially.
Well, yeah, they're not supposed to be, right?
Right, they're not. It's agency with independent doesn't even make sense.
Right.
Like, but
Yeah. I'm an agent that serves no principle.
I'm an agent that serves
That's
myself.
not how
I
that
don't
works.
serve anything. Yeah, right.
So if that's the case, then if Congress were to say the president can now make all the laws, it's too hard for us to make laws, the president can just do whatever he wants. That would be what do you have effect? You have a unitary executive and legislative.
You have a
branch at this
unitary
point.
everything.
You have basically have a monarch.
have
You
Caesar.
have a tyrant. You've created a tyrancy.
Okay, I think
Tyrancy?
we're freaking people out
Yeah,
now because
that's
I don't
true.
think
That's
that's
true.
going to happen.
But
So
we
let's
need
go.
the non-delegation doctrine is all I'm saying.
Yeah. And I think now we're ripe. I actually feel very positive about this because I think it prompts Congress to step up and do its job.
I hope
which,
so.
I mean, and remember, we pit ambition against ambition in our government, and Congress has the power to limit the executive power. I think once it gets its act together, it might take a little bit, but I think it probably will. And these other structural issues will hopefully start to sort themselves out.
Yeah, I hope so.
One tangential issue, maybe we don't need to talk about it, but I just found it interesting. They go through the Federalist Papers and Madison's writings of all these
50
founders.
pages of this.
So much of it. How is that doing originalism? Is it doing originalism to look at what the founders said at the time of the founding and say that's what these words mean in the Constitution? Because when we think about originalism, we're talking about original public meaning, not originally what these guys who are very revered, smart guys, what they thought. And so is it doing originalism? Is that what Roberts is doing here? Is he being an originalist by looking at what they said? Or would it be better to make it more nuanced? What would the public have thought at the founding?
Well, I think that the Federalist Papers are a pretty good
They're a
indicator
good
of what
indication.
the public would have thought.
Because the public ratified the Constitution through
in part because of
of
the
the
Federalist
Federalist
Papers.
Yeah, but are we looking at the Federalist Papers?
Also,
Yeah, go ahead.
Not to say that what the Federalist Papers say goes, but rather to reemphasize that what the text of the Constitution says is what it means.
Yeah.
Because no part of what is said in the Federalist Papers contraindicates the actual language of
because they were advocacy
Constitution.
pieces for the Constitution.
Right.
If it was like the text was like wildly different from what the Federalist Paper says, then we shouldn't use them.
But I think that in
good
this
evidence.
case, his use of the Federalist Papers.
Plus, remember the text says the executive authority shall be vested in a president. So,
but I think that's the difference.
Complicated.
But I think that's the difference between originalism, like what it should do, and what sometimes we get confused about is that originalism doesn't take into account the original intent of the framers. It takes into account the original public meaning of what the framers wrote and what was enacted as the Constitution's text.
And tune in next week for more conversations about the nuance of opinion or of original intent versus original public meaning.
Let's go.
But for now, let's move on to Trump versus Cook. We've just got a few minutes left.
6-3.
Oh, yeah, what's our score?
Trump v. Slaughter, 6-3 on ideological lines. Court overrules Humphrey's executor and says that the president is able to remove an FTC chair from office, and that renders the statutory protections for that office inoperative. And as a dad joke, Humphrey's executor has been slaughtered.
One of our interns made a joke about
noise.
how Humphrey's executor survived him. And it was like, that's bad. Okay, anyway.
Also, there's a big ripple effect on other agencies, too.
Trump versus Cook. So now we've said all of those things. You would think that the answer to, okay, so can Trump unilaterally remove a Fed chair would be yes. Yes, he can. Turns out the answer is probably not. And it's important that it's probably not because this came up to the court in our favorite posture, which is preliminary injunction. So this came up on the so-called shadow docket, the shadow docket.
So whether to stay a preliminary injunction, so fun.
Right. So the answer to this question is couched in the probably, because the question that's really being asked is the government likely to succeed on the merits? And the answer to that is they're not likely to.
But we don't know yet.
But we don't know yet. And actually that is an important point that is drawn upon by a couple of our dissenting justices. But importantly, we do have a majority opinion here, and who's on the majority in this case?
Who's the author?
Justice John Roberts. Same guy.
Same guy writes both of these opinions.
So Justice Kavanaugh and Justice Roberts jump to the liberal side of the court, and say that no, President Trump cannot remove Lisa Cook for cause. Now, the structure here is a little different in how this actually comes before the court. So unlike in Slaughter, where the president just simply says, you're not what my administration wants for this agency.
He had overtly political motivations.
Right. Cook came up in the context of some allegations that she had committed mortgage fraud. And so he says, I'm removing you, but I'm removing you for cause.
Yeah, I'm trying to satisfy the statute here that we overturned, that we struck down in the Slaughter case.
And very importantly, doesn't give any sort of legal notice of this. He tweets about it, posts on X, I suppose.
Like, you're fired.
Yeah, and then sends her a letter saying you're being removed for cause. But she has no opportunity. She has no formal notice, no opportunity to make her case, no opportunity to defend herself whatsoever. And she is simply removed for cause. And so the question that comes before the court is, while this case is pending, is she allowed to keep her job? And in a minute, Nathan is going to get very excited about the weirdness of the remedy in this case. But for now, the answer is yes. According to the court, she is allowed to keep her job.
And the government in litigation also did not make the same constitutional arguments that we were just discussing for the Slaughter case.
Yeah, so
they expressly waived them.
There's two important reasons, at least in my view, from what I can tell, that this goes the opposite way. The first is party presentation. We've talked about this until we're blue in the face, I feel like, on this podcast, which is the arguments that the parties make actually control the outcome.
Yeah. They're the question that is presented to the court, and that's the only question that the court can answer.
And the government here raised some really weird arguments, but one of those arguments was not the president can remove, and that the for-cause requirement itself is unconstitutional.
Yeah, they didn't say that.
The reason that they do that is not just a random court-created rule, but it doesn't do justice to the issue if the court just sort of hypothesizes about what other cases that could exist and what they might have argued, right? And so they can only decide on what the parties actually say they're arguing, what they've litigated all the way up to the Supreme Court.
And the concern is if they're weighing in on questions that were not presented in front of them, then that starts to look a lot like legislative power, which they're not allowed to wield. So they just have to answer questions that litigants bring before them.
Yeah. Right.
Because that's judicial power.
And the second reason that this goes the other way, again, from what I can tell, is that Justices Roberts and Kavanaugh believe that the Fed is something different. It is not like the FTC. It is not an agency per se. It is a bank. And Justice Roberts dedicates a good portion of his opinion to describing the history of the first two national banks that we had and saying the Fed is just another one of those.
Yeah, and those were accepted back in the day.
As early as the founding.
The founding, right. We talked about Madison, decision of 1789, all that.
Even
at that
McCulloch v.
same
Maryland
time,
was about the legitimacy of the bank.
Which was upheld.
Yeah.
It was necessary and proper to like commerce and taxation and spending and stuff, vaguely everything bundle. And so the bank was upheld.
Yeah. It makes for kind of a weird, so there's a term that Gorsuch uses in his Slaughter opinion that there is no headless fourth branch when he's talking about the agencies. I'm talking specifically about independent agencies, but it seems to me that what Justice Kavanaugh and Roberts and company are describing is exactly that. It's a headless fourth branch. This is not executive in the sense that this is not an agency that's creating and promulgating rules to enforce Congress's will. It's not that. It is semi-private in a very weird way. It's some, to a certain extent, owned and operated by private companies. So, like, what is the Fed if you're not going to say that it's a headless fourth branch?
No one knows what the Fed is.
It's just a bank, but it's like chartered, even though the Feds can't charter anything.
Bank.
Yeah, but a lot of the distinction that they discuss, the majority and some of the concurrences, Kavanaugh's concurrence, I believe, is kind of the main one to emphasize this, but it doesn't have regulatory. It's not like the FTC or the SEC or all these things that promulgate rules and then the rule has binding force of law upon a private citizen. The Fed works differently, and it works according to the court in the way they described it. Works more similarly to the first and second national banks in that it's just basically like it uses its economic heft to like sway the economy through setting interest rates, and they're not binding regulations in the same way, so they're not executive. But other justices disagree.
Here's the thing, though. We just read in Slaughter that there's no such thing as like the fiction of a quasi-legislative, quasi-judicial.
Okay, but they're not saying the Fed is quasi-judicial or legislative.
I know, but what is it? We can say
if
what
not
it's not.
executive, what? Yeah,
It's
I mean,
like
I agree
the
that
first
it's
banks that were accepted.
It's a headless fourth branch. Honestly, it's because it's doing something that no other branch can or should do.
Mm-hmm.
I mean, maybe the executive, I suppose, can set policy and buy bonds and things like that. But
well, yeah,
okay, but like
choose to set its.
I mean,
the Constitution creates three
rates?
branches of government:
right? Yeah,
executive, judicial,
the
legislative.
Constitution's not affirmatively creating
which
your power,
one
then you
is the
can't.
Fed under?
Yeah,
Like, just tell me and I'll be happy.
But Roberts and Kavanaugh are assuaged on that front by the fact that this is very similar to the First National Bank, which is very, very old.
And
very,
not
very
just old, but
does not mean it existed in the Constitution.
And as I remember from the way that those were set up, and I am not an expert on any of these, just a disclaimer.
To be clear, we are not.
We are lawyers. We are not economists. But the early banks were, they were like investment projects of the feds. So like the feds could tax and they could spend on the general welfare. And so they spent their money on investing in a private bank. And then the private bank had some public oversight somehow, which wasn't executive.
So I have the statute here. So the first you're talking about the first and second national banks.
Yeah.
The second national bank is the one that was litigated in McCulloch v. Maryland. And the Congress created that bank. It had 20%, the United States had 20% ownership, or 20% of the shares of that corporation. So 80% of the shares were public.
Yeah.
The corporation the second bank had 25 governors on its board, and 5 of those were appointed by the president with advice and consent of the Senate. And I think the language here, let me get the language in the actual statute pulled up. It says, at the end of talking about how they're appointed, it says, but the president of the United States alone shall have power to remove any of the directors appointed by him as aforesaid. And it's talking about that, I think, specifically because the other 20 board members of this agency they were voted on, and there was like a process for appointing them and removing them. And the Congress is making sure that the removal process that could be used for the other 20 members could not be used on the members appointed by the president, that the president alone. So it wasn't delegating power to him. It was just saying only the president could remove them. And I think that's important because we'd already decided that the president could remove them.
Yeah, it supports the other. That's interesting. Even though it wasn't an executive agency, they were like, but just in case the president's in control.
The president can remove them.
Yeah, so
it seemed to be assumed that the president could do it.
I feel like that's the opposite of assumed. If they said it outright, the assumption seems to be that he couldn't, and so we need to actually put in writing that he can.
Well, when it says the president,
you can take it back.
You can read it that way.
You can read it either way.
Yeah.
The point is, it was. What we have today significantly mirrors that, or mirrors it sufficiently that Justices Kavanaugh and Roberts flip on this and say, so this one's different, and therefore the president needs, and this is again with some hesitation because the question wasn't squarely asked about the constitutionality of the for-cause requirement, but assuming that it is constitutional. This is the conclusion of the court. The court decides this application on the narrow ground that the president failed to afford Cook the procedural protections to which she was entitled by statute. Without such protections, she could not properly dispute the charges the president laid against her. The court need not address Cook's constitutional due process argument, for the statute alone makes it unlikely that the government will prevail on appeal as to the validity of the procedures used to fire Cook.
So this is a statutory case?
It is.
And the other one is a constitutional case.
Exactly.
And they're very different.
It said she's entitled. But like, what does that mean? Like, before she could be fired, she's entitled? And Thomas really tees off on this, because what Thomas says in Justice Thomas says in his dissent is that doesn't make any sense. He said Cook's office was not her property because in this country, government officials do not own the public offices in which they serve. In other words, she's not entitled to anything before she loses her position,
constitutionally
because she doesn't have a property interest in her job.
Yeah.
So she has property interest in money that she's getting paid.
Yeah. So the due process clause doesn't apply, but there's a
statute
statutory entitlement,
itself.
and the statute, provides some level, although it's not entirely clear.
But does it vest like a right in her to her job, or is it
it's a statutory entitlement?
Yeah, but is it meant to benefit Lisa Cook herself, or is it meant to be a structural, this is how we're setting up this position? And I think that's really important because...
They seem to be the same, no?
No, because Lisa Cook getting money would be something that she, like her salary, in other words, would be something that she's entitled to because she gets paid for the work that she's done.
She's entitled to her job being, I don't know, executed or secured in the way that the law says it is.
Well, what Justice Thomas is saying is that that's not the case. She doesn't have an interest in that. The American people do. The rule of law has an interest in it being executed properly. But Lisa Cook does not have that interest.
Well, importantly, Thomas was in dissent by himself.
Right. And by himself on this one.
On that particular point. There were a lot of dissents, but that was...
I know, but Justice Thomas is right.
I don't know that
Beth and I
agree. But I see where you're coming from, and I see where Justice Thomas is coming from.
It's true on the constitutional point. Nobody has a constitutional
on the constitutional point, but on the statutory point,
job.
That if the statute says this is the process that you are due, then you're due that process, and that, as it happens, is just very simply for cause.
I think I agree with Laura Beth, and I'm so glad that listeners can understand the debate process that goes on.
So we do disagree a little bit, but I got to move us on because we are running very short on time.
Justice Thomas, fine.
we got to move on. So let's talk very briefly about what Justice Alito and Justice Gorsuch have to say about this, which is you all decide way too much at this stage of the litigation.
And Barrett.
And Barrett, you guys are deciding way more than is necessary. Basically, they say the lower courts issued two specific issues or decided on two specific issues, both of which were nonsense. One is that for cause only means in office conduct, so you can't be removed for anything you did before you took office, which is just kind of mind-boggling in how broad that is. If I commit an act of murder and it's not discovered until after I'm confirmed by Congress for an office, I can't be removed. Like, that's insane. And then also that she has a property interest under the Due Process Clause, which is exactly what Nathan just articulated and what Clayton and I think both agree is nonsense. So, like, Justice Alito and Justice Gorsuch are saying we should have just reversed, guys. We just should have reversed this nonsense opinion.
Yeah, this is a preliminary injunction. It's about likelihood on the merits. It's about some of the other preliminary equitable factors, which Justice Jackson talks about. And we just don't need to reach and go out and like decide this as if it's a monumental constitutional case like Slaughter is. I almost feel like they were sort of like they had to justify that. They felt like they had to justify the inconsistency between Slaughter, the apparent inconsistency between Slaughter and this case.
Well, Justice Alito and Justice Gorsuch were both consistent.
Yes.
Yeah.
Well, yeah, but I mean, to the extent like this is just a long opinion, and so these three justices in dissent are saying, let's just.
We didn't need to get to this. Yeah, we should.
Just like this is a preliminary injunction, and
I feel like this
is on
one,
different issues. Just stop.
Yeah, I feel like this is one where it might come down ultimately when this finally resolves that Lisa Cook may not have her job after all.
And I do wonder if this question had been asked more squarely, if it would have come out differently. That is, if the government had come forward and argued exactly the same as they did in Slaughter, hey, the Fed belongs to the president, which I don't know that they'd win on that point because I think they'd still lose Roberts and Kavanaugh.
That, which suggests they don't think they'd win on that.
But they waived it, yeah. So if they had taken that position and said, and the president wants to fire Lisa Cook because she doesn't align with his political interests.
That would have been one way. They didn't take that way at all.
They didn't go that route, but if they had, I do wonder if it would have gone differently.
Then they would have been justified in writing a lot about it if there was an inconsistency. But right now, this case is about the president trying to satisfy the statutory for cause provision or text, and him likely not doing that by just writing a letter or whatever and putting it on Twitter. Whereas the other case is about whether he has the authority altogether. So it's very different.
Yeah, they tried to shoehorn this into for cause and say, yeah, no, this is for cause, nothing to see here. And to make an interesting statement that Justice Thomas actually agrees with, which is that the president gets to decide what for cause means. That is entirely left to the discretion of the president.
Right.
And the court addresses that and says, no, Loper Bright, just like go read what we said there.
It's a statutory term of art. It's been around for so long.
It means something, and we as the court are allowed to say what it means.
Yeah.
It is
and
the
Congress
unquestioned
put it in there as law, and we say what that means. The president doesn't say what for cause, doesn't decide. I think that's just the same as at will.
Yeah.
But this is almost like a prosecution, right? The president says, I'm removing her because X reason, and then the court says whether or not that meets the for cause requirement. That's what this holding is. That's really all this holding is.
Yes.
No,
but for cause is a
'cause-
statutory requirement.
Well,
Yes.
That they define.
Well, no. So they're deciding on even narrower grounds than that. They're saying they're not answering the question of whether or not this meets for cause. They're
Right.
saying she's entitled to notice in a hearing. And so go back and fix that, and then we can talk about whether your for cause is sufficient.
Yeah, but like the underlying claim is that the president, if he's saying the mortgage thing doesn't meet, like that is for cause, that's good cause to remove her, then the court gets to assess whether or not that's true. It's
Yeah,
not
at
the
the end of the
president.
day, you're
Yeah.
right. Yeah.
Yeah.
The court does have that oversight ability to say,
Right.
yeah, thumbs up or thumbs down. Yes, this thing that you have on the facts decided that she's done. They haven't established that yet.
Right.
But if on the facts you
Right.
decide that she's done these things, then we as the court can say as a matter of law whether those things are sufficient to constitute
Yeah.
for cause or not.
Yeah. Yeah.
So that is where we land on that. Nathan, give us the scorecard. We have run so long. Our poor producer is going to kick
Yeah.
us out of his recording office.
All right,
recording
I won't
studio.
read any more Justice Thomas. I'll just say 5-4, so a very narrow opinion. Chief Justice Roberts and Justice Kavanaugh side with the court's liberals to say that the Trump, at this stage of the litigation, is unlikely to prevail on the merits and will not be able to remove Lisa Cook from office.
And there's a lot of tea leaves talking about how the
Yeah.
Fed is different from the other agencies.
Yeah.
We'll see how that shakes out at the end.
Yeah. And Roberts goes out of his way to say, we're not casting any doubt on the Fed. Nothing to see here. We're not going to do that. So,
We'll see.
All right. Well, thank you both for your input on all of this. It's been a really fun
Thank you.
conversation today. And for our listeners, if you've enjoyed our conversation today, leave us a review and join us next time for more Rightly Decided.